On the record in the matter of the people of the state of Michigan versus Satie Cook, 24-03654, council appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Is Mr. Mataloni
Good morning,
there?
Mike. Yeah, good morning, Mike Mataloni on behalf of Satie Cook.
Okay, Ms. Cook is present via Zoom. Ms. Cook, can you hear us?
Yes.
Okay, today was the date that was set for probable cause conference. This is for accessory after the fact of the felony. There is a preliminary examination that's scheduled for next week, but my understanding is that there's going to be a waiver. Is that accurate?
Yes.
Is there an offer?
At this time, there is no offer on this case.
Ms. Cook, you understand that you have the right to have a preliminary examination here in the district court?
Yes.
You understand the purpose of that examination is to require the prosecution put forth evidence that would establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you the crime.
Yeah.
You wish to unconditionally waive your examination today?
Yes.
Is anyone threatening you to do that?
No.
Has there been any promises extended in exchange for your waiver?
No.
You understand that once you waive this matter, the matter will be bound over to the circuit court for further prosecution up to a jury trial, and that you can't change your mind if you don't get an offer that you may get extended at the circuit court level. You understand that?
Yeah.
The bind over date is January 15th. That's the date the circuit court's going to get the file from the district court. You do not need to appear in the circuit court on that date. You understand?
Yes.
Your next court date in circuit court is going to be a pretrial. Your attorney will be made aware of that. Can you give me your address, please?
160 Twin Ponds Lane, Okemos, Michigan.
Okay. A bond is set at $5,000. Personal recognizance that will continue. Any additional matters?
Yes, Your Honor, if I may. I did speak with Mr. Mataloni briefly. Because I'm switching the courtrooms on Monday, and I know that a new prosecutor will be taking over, I'll inform Mr. Nagel. To one of the witnesses in this case, Jaden Pavona, she does work for Mr. Mataloni as a legal assistant, so I just wanted to put that on there.
You said one of the witnesses?
Yes, Your Honor. Now, Jaden Pavona was certainly involved with these people, potentially not this incident. We don't have any charges pending for Jaden Pavona involving this incident. I just wanted to put that on the record.
Mr. Mataloni was aware of that?
Yes, Your Honor.
You're muted, Mr. Mataloni.
I'm not muted.
You were muted.
Okay. Yeah, I'm aware of it. I don't think it has anything. There's no conflict. There's no reason that I can't continue as Ms. Cook's lawyer.
That was, you made that determination upon yourself, or you sought advice from the state bar?
I made that determination on my own. I know what a conflict is. There's no conflict.
Okay, I'll follow up with the state bar on that issue. Any additional matters for today's record?
Nothing from the people. Thank you.
Thank you. You're all set.
Thank you, Judge.
Thank you.
On the record in the matter of the people of the state of Michigan versus Anthony Enright, 24-03717, council appearance.
Good morning, Your Honor. Casey Markarian, appearing on behalf of the people.
Does Mr. Enright have an attorney?
Believe he's applied for court-appointed attorney, but we don't have one assigned yet.
Okay, why do we not have one assigned? Did Mr. Goodrich, do you have any idea why Mr. Enright does not have an attorney?
Your Honor, I will check in our system just a moment here. Is it EMB? How to spell his name?
It's Enright, ENRIGHT.
I don't show anything in our system for this case yet, but I will check in with our office on that.
He was arraigned on the 19th of December, so.
Okay.
You don't have an intake?
I don't see I don't see an intake, no.
Okay, when we get a chance, Mr. Goodrich, I'm gonna put you in a private meeting room with him so that you can get the appropriate information from him. And then I'll treat next week as a probable cause conference. On the record in the matter of the people of the state of Michigan versus Justin Fountain, 24-03-726, appearance, please.
Good morning, Your Honor. Casey Markarian, appearing on behalf of the people.
Attorney Luke Goodrich from Public Defender's Office, here to represent Mr. Fountain, who's appearing from the Ingham County Jail today.
Mr. Fountain has a preliminary examination scheduled January 10th at 8:30 in the morning in person at the court. And this is for count 1 of assault with intent to create bodily harm less than murder or by strangulation. Count 2 misdemeanor domestic violence. Are we continuing to exam?
We are, Your Honor, and we would like to address his bond situation.
You can proceed.
Hey, thank you, Your Honor. Your Honor, he currently has a $7,500 10% bond in this matter. He's also been remanded on a probation violation from many years ago, which I think is scheduled in front of Your Honor on Monday. Since his time in jail, I don't think he hasn't been able to contact anybody about even getting the $750 for this current case. I wanted to see if the court would be willing to either reduce that or to make this one a PR bond with the understanding that he would still be in court on Monday. He is hoping to maintain his employment that he had been working prior to getting arrested in this matter. I don't know what's going to happen on Monday, obviously. But if he were to get time served, we wanted to try to set him up so that he would be able to be released at that time, Your Honor.
Okay, so he has a probation violation that's pending before me on Monday. I'm assuming for an absconding from probation. Is that accurate?
Yes, it's on an old marijuana case from many years ago.
So, but how much credit does he have served on that?
He, I believe he's been in jail for, I think it's up to about 16 days on that since his arrest. I don't know what he had up front on that matter. But I think it'll be up to 19 or so when he gets there Monday. It's my understanding.
Oh, so.
Or maybe it'll be 16. I'm sorry. I may have those numbers confused. Like I said, I'm not representing him on that matter. Mr. Raleigh will be there for that, but it's right around that.
I don't know, but okay. I don't know what I'm not familiar off the top of my head with his other file. I know that's set for Monday. It's probably more appropriate to make this bond on Monday because we're not going to assume that he's getting credit time served if he's found to be guilty of a probation violation. He may get the full extent of the time.
Okay, and I would have no objection to Mr. Raleigh addressing, bond on this file, depending on what you do on the other file. at that time.
Okay, your motion has been noted and I'll hold the ruling in abeyance until I address the other file, because I have no clue what's going on in that file.
Okay, it's understandable, Your Honor. Thank you.
Any additional matters for this file?
Nothing from
No,
the
Your
people.
Honor.
You're all set for today, Mr. Fountain.
Thank you.
Just need to go with where the Monday file is. Mr. Girish, I'm gonna put you in a meeting room with Mr. Enright.
Okay, thank you, Your Honor.
Yes, please. On the record, in the matter of the people of this state of Michigan versus Ryan Phineas, 14-01489, council appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Noah Thalen on behalf of Ryan Phineas, who's present via Zoom.
Okay. We have a 2014 case here. Let's see. There's 3 counts of controlled substance delivery, manufacturing, and a count 4 of conspiracy to commit controlled substance delivery, manufacturing, that's scheduled for preliminary examination on January 10th at 9 o'clock in the morning. And my understanding is that there's a request for an adjournment and to address the timeline. Is that accurate?
Yes, Your Honor, that is accurate.
People have no objection to that request, Your Honor.
What's the purpose of the request?
My client was granted on the 27th. He lives out of state. He lives in Texas and he travels for work. He is in Biloxi, Mississippi until after that date. And he does have a few other work related events. So we would just request it to be pushed until February.
Okay, Mr. Phineas, you understand that you have the right to have your preliminary examination on these felonies within 21 days of the date that you're arraigned?
Yes, Your Honor.
Okay, and so due to your personal conflict with the schedule, you're requesting to waive the 21-day timeline so this could be reset?
Yes, ma'am.
Anyone threatening you to do that?
No,
Has there been any promises made to you if you waive your timeline?
no, Your Honor.
February 27th at 8:30. February 27th at 8:30 in person at the court.
All right,
Any
thank you,
additional
Your Honor.
matters for- Thank you. Any additional matters for the record?
Nothing from the people.
Nothing from defense, Your Honor. Thank you and have a good weekend.
Thank you, same to you. Have you seen Roman Smith?
Not yet, Your Honor. I don't know if he's checked in on them.
No.
I don't know, somebody in the hallway.
Is Roman Smith here in the hallway?
I can go check.
He doesn't have an attorney? Roman Smith? Retain, I think. Yeah.
Yeah, this was the one that advised us he was retaining counsel. I think he provided a name.
William Amadeo.
Yeah, we just never got to the appearance.
Sounds good. Written motion.
Just say it was wrong.
So there was a written.
No, he just said.
On the record in the matter of the people of the state of Michigan versus Deontay Wright. This is file number 24-02791 FY, council appearance.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Gigi James appearing on behalf of Deontay Wright.
Morning, Your Honor. Toby White here, co-counsel with James.
And this is Mr. Deontay Wright.
Yes.
Okay, today was the date. On my docket, it says a motion hearing. I think there was originally a motion to show cause. Alright.
That is correct, Your Honor. Our office has show called 2 witnesses because they did not respond to a subpoena. They did, however, after receiving the notice of show cause, come in and provide all relevant information. So we released them from that show call.
I remember signing an order as it relates to that. However, as I appear today, I get a copy of a motion, which obviously I haven't read because it was filed yesterday.
Your Honor, I was responding to Mr. Markarian's email that he sent out objecting to our representation.
Okay, if I'm recalling this issue correctly, Ms. Markarian had a concern about a conflict in representing your client because there was previously some level of consultation with another party?
That's correct, Your Honor.
Okay, and that your understanding or belief was that there was efforts made to flush out that conflict from Mr. Wright's firm with the state bar. And then upon your engagement with the state bar, you determined or believed that that did not take place. Is that accurate?
Yes, sir. And frankly, I'm not going to say definitively whether these things did or did not take place. I think that would be unfair.
So that was your belief, though.
But that is my belief. I'm not participating in their calls. I don't know what calls have or have not been made, and frankly, all the calls to the state bar are confidential as is. So what I did out of an abundance of caution and concern when I had time for it, and I understand the response and the motion to 21 days before I called the ethics hotline, as I'm sure Your Honor is well aware, we have very busy schedules with our docket, so I tried to get to it as soon as I could. When I called the state bar, I tried to explain a similar factual summary of what my concerns with this case were. That someone was involved in a home invasion, someone was shot, that the person who shot the home invader had spoken to police, but also had expressed that he did not want to continue speaking to police until he talked to his attorney. I then advised that there was a phone call conducted with Mr. White at that time on that date with Mr. Wilson. Whether or not it raises to the level of a consultation, legal advice, and all that I think are more appropriately addressed by Your Honor. My concern and the reason why the email was sent was specifically because the state bar told me to. The state bar told me to formally object to this. The state bar told me I had an obligated duty to report. While I am a little newer to this profession, and I do take those duties and obligations very, very seriously at this point, I don't ever see those things fading in my career either, Your Honor. So whether the state bar had told me to do this or not, I was planning to at least raise the issue with Your Honor once more so that we can have a ruling on it before we proceed any further on this case. There's been a lot of discovery requests made by the defense. I'm not saying whether or not they're fair, but it is a little uncomfortable for me in an ethical position to continue to go above and beyond as I would normally do for most defense counsel when it comes to discovery requests, when there is this looming question unanswered in the background. Not to mention that, but based on consultation with the victim, Jacob Wilson, he was very upset to hear that Mr. White was representing the defendant now. Whether his concerns are valid or not, whether his concerns are legal or not, whether he gave a voluntary statement or not is not the issue here today. The issue is whether or not a conflict exists, whether or not the White law firm, by making that consultation, has made themselves a witness to this case, and whether or not they can continue to represent Mr. Wright. I apologize if this came off as some sort of vindictive act on my end. Timelines are what they are. I tried to get this all done within a month. It took a week to get the email to you because I had my superiors review it and try to go through the course of conduct that was appropriate to handle this matter. And frankly, I don't think a week is very long in the legal world anyway. So I will give myself a little bit of credit of trying to get to this, Your Honor, as soon as I can and before a preliminary exam. With that, I think I've kind of said everything I need to say. And if Your Honor has any questions for me, would like body worn cameras or whatever, I'm happy to play. I guess I might also add, one of the other concerns for me, and that raised this to the level of me feeling the need to call the state bar, was at one point when we were negotiating and working on this case, Mr. White suggested that we charge Jacob Wilson as a part of this case in exchange for, and give his client a reduced home invasion. So I guess I have a concern about being an attorney telling someone to speak to police, then representing someone else, then asking for that same person he told to speak to police to be charged based on the information he gave to police. That's my concern. I have copies of the emails if you'd like. I have whatever you want. Yeah.
Okay, counsel.
Thank you, Your Honor. Yes, first, I'm highly offended that Mr. Markarian would say he does not think we talked to the state bar. That's pure speculation. I am an officer of the court. I hold that to the highest ethical standard. I would never present information to Your Honor that did not take place. Our office did call the state bar on September the 27th, the day of the probable cause conference after it ended. Mr. White got a call back on October the 1st from Alicia Chandler, state bar representative. He explained the procedural facts.
So you were present for this call?
I was not present.
Okay, well, why are you telling me what happened then?
I will tell you what happened.
He's just sick and battling a sore throat, but.
She's not representing you.
She
Right.
and she was, I know she overheard part of it because it was in the conference room and we had it on a speaker call.
Yeah,
So,
but I don't need to have hearsay if you're right here.
yeah, well, that's fine. I called the bar and the bar called me back, as she said. I explained to the bar the circumstances of the situation. And we went over the conversation and the nature of the conversation. The conversation was like this. Over an hour after 2 police officers had interviewed Mr. Wilson.
So you'd already been interviewed by police.
From the state bar.
Oh, just the bar?
With Alicia.
She told me it was not a conflict. She said that you didn't represent him, telling somebody
You're saying you spoke with Alicia Chandler?
twice, once now and once more recently.
We followed up December the 20th, December
Right.
19th, after receiving Mr. Markarian's email. And again, we presented the facts, the content. She wanted to know the content that was spoken to Mr. Wilson, the subject. She said, I do not see where there is any representation there. She said, even analyzing this under prospective clients, there was no suggestion to represent anybody. What Mr. Markarian is leaving out is when Mr. Wilson spoke with Mr. White, he had already been Mirandized, voluntarily waived, and gave a full hour-and-a-half detailed, very descriptive, even reenacting statement to not only the first officer that arrived on the scene, Officer Uberoth, but also to Detective Salma when he arrived an hour later. Mr. White and Mr. Wilson's conversation was very benign. I would love for you to see it. Mr. White said, hello. First off, Mr. Wilson didn't call us. Some lady called and erratically said, the police have my son in the house. I don't want him in there. We didn't know who she was, still do not. And Mr. White said, what's going on? She said, I don't know. I got called here and the police have my son in the house. Mr. White did say, well, he shouldn't be talking to the police if he's not represented. So it goes silent. You can hear some commotion in the background. It sounds like they're passing the phone around. Then you can see on Officer Rubenau's body camera, a young lady goes to the door, hands the phone. Mr. White says, hello. Mr. Wilson says, hello. Mr. White said, you shouldn't talk to the police. You know, if you're a victim, he said, oh, I'm not a victim. He said, I'm the victim. I'm not under arrest. They said, I'm not going to be arrested. I'm not in custody. And Mr. White then goes on to say, oh, well, if you're the victim, you're fine, and talk to police, cooperate. You're already talking to them. Just be honest. If you're the victim, it's only, he does say it's only if you're the subject of a criminal investigation. They think you did something wrong, then you want to work through a lawyer because you just don't know. That is the entire conversation. We knew no charges. We knew if he was charged. We didn't even know why the police were talking to him. He didn't offer it. We didn't ask it. It was very benign, very sterile. There was no talk of any future representation. In fact, he assured us, I'm the victim. I don't need an attorney. And Mr. White said, yeah, you don't. And again, this took place an hour and a half after he talked to two different detectives and gave his full version of statements. So the fact that Mr. Markarian would say that he said, I only talked to police after speaking to Mr. White is just, it's untruthful.
Well, maybe that's what he told Mr. Markarian. We can't.
And
but
but
that happens.
And my thing is, I think Mr. Markarian should know it's untruthful because he keeps referencing the same video I'm talking about. The entire incident is called on Officer Woodward's body camera. I know he has access to it because we got it from their office. So,
And if Mr. Markarian gets conflicting information from a victim, and then it's his responsibility as a member of the bar who have freshly taken in PRE, and to go and flesh that out, and maybe whatever his communication was with the bar caused him to believe that there was something else that needed to be fleshed out until he's only doing what they told him to do, which is to bring the issue to the judge. So I don't believe that we should look at this as there's one attack against the other. It's just an issue that probably needed to be fleshed out and could have probably been fleshed out between the two of you all before bringing it to the judge. But again, he's newly minted into the bar, doing his due diligence, and he's told to bring it to the judge. So I can understand why I would do the same thing. I don't believe that he is or has made or is making a personal attack on the veracity of what you're saying. Everyone, the three of you all are officers of the court. I have no reason to believe what any of you all are saying as it relates to your perspective from this.
right.
So you both want to say
Yes.
something.
I think for me, it was the timing of it. Again, we subbed in, we appeared at the PCC on 9/27. Mr. White did say on the record with Mr. Martinez, there could be a potential conflict. Then Mr. Martinez did follow up with Mr. White and say, I don't think there's one, but we followed up with the bar anyway. My thing is Mr. Markarian now says out of an abundance of caution, but that was September the 27th. He never raised that issue again until on a phone conversation on 11/20 while we were negotiating. And as your honors heard him say, we made some very difficult discovery requests, but we're entitled to the discovery and we want it. I understand it may be difficult. On that particular day again, during this conversation, he raised, oh, did you guys speak to the state bar? And I did forward an email that I had sent to your honor staff along with a substitution saying we had spoken to the state bar and that the state bar had determined they didn't think there was a conflict because there isn't any representation there. That's exactly what was said. And again, Mr. Markarian thanked me for the email. He was fine with that up until he says he called the state bar December the 11th. Okay, they told him to follow up with the court as he should have, and I would have. But out of an abundance of caution, I don't understand he didn't do it on the 11th, hanging up the phone, the 12th, the 13th, the 14th, the 15th, the 16th, the 17th. He does email the court on the 18th, which is a coincidence to me because on the 17th, as your honor mentioned earlier, we show cause two of his witnesses. We know that they didn't like it. We spoke to family members. We did clear that up. On the 18th, we served the homeowner where this incident happened at. We subpoenaed her and we had her served. On the 18th, within an hour, Mr. Markarian then emails the court this information. So it's just a coincidental to me. I just felt like he didn't like our discovery request and how we were handling the situation, and he was retaliating, and I could be off base there. But out of an abundance of caution, this could have been in September. It could have been done in October, November, surely well before December. I mean, if we're really being cautious, and that's what we're doing.
Okay, I have a note here from September where it was stated on the record that there was a potential conflict that Mr. Wright's office, it said, my note specifically said that he was going to be retaining Agent James and that you provided information that you would flesh out any potential conflict. And if there was no conflict, there would be a substitution of counsel. I have no reason to believe that that you didn't make or someone from your office didn't make communication with the state bar. I also don't have any reason to believe that Mr. Markarian didn't have an interaction with a witness that maybe caused this later series of events. I don't know that Mr. Markarian was seeking to be vindictive. He's been before this court for several months now. I've not had any occasion to believe that. And even looking at the response to the motion, I don't believe that you're disputing that I think your issue is that you thought that this interaction with Mr. Wright happened before there was a statement made?
It was before, and just to clear up the timeline, if I may, Your Honor, because I reviewed the body worn camera several times. Ms. James is right about that. I even did it again this morning. She is accurate, and I would say her motion has a pretty good factual summary of what happened, aside from the fact that very detailed statements and reenactments were given before Toby White was talked to. That's my concern. The factual basis and the series of events that I reviewed on body worn camera today is the first statement she's talking about him giving. It did not last an hour and a half long. It did not involve a detective. It was Road Patrol Officer Bailey Uberoff, who was trying to get information from Mr. Wilson after he had been Mirandized from the backseat of his squad car while Mr. Wilson was still in cuffs. I don't think there's an issue of voluntariness there because Miranda kind of saves it, Your Honor. But to put it in context, the first statement we're talking about was made to a Road Patrol officer while Mr. Wilson was still in cuffs. Okay. Then the next statement that Ms. James is referring to with the detective is after Detective Salmon shows up. He shows up, he is informed by patrol as is standard of what the situation is, and he decides he wants to try and get a statement from Mr. Wilson again. He tries to talk to Mr. Wilson. Mr. Wilson does engage him somewhat, but prior to that even happening, you can see on body worn camera family members, the ones who I assume called her, coming up to Bailey Uberoff's car, telling Mr. Wilson not to speak to anyone until he talks to his lawyer.
Okay, so let me stop you there.
Detective Salmon gets there.
Let me stop you there.
Yes.
So there was, Mr. Wilson has already given a statement to Officer Uberoff. And then Detective Salmon shows up. And then family members are saying you shouldn't talk to the detective until you talk to an attorney.
That was prior to the detective even getting there.
Before, okay, so
correct.
before.
So while he was still in the car and Uberoff was at his computer, you can see a couple of the family members come up, shouting through the window and expressing concerns to Officer Uberoff about not speaking to someone until he speaks to an attorney.
Okay, and so your understanding is that that's when the call to Mr. White's office took place?
That would be my guess, Your Honor, but it's
Okay.
just a guess. I'm not
Got
trying
it.
to say, I don't have timelines. I don't know when the call was
Okay,
or was.
got it.
Your Honor, I can clear up that timeline. Also Uberoff, even though Road Patrol was the first arriving officer on the scene, he did place Mr. Wilson in the back of his car. He made it clear you're not under arrest. You had a firearm. This is just for safety reasons. He Mirandized him. He said he kind of gibberished on, do you understand? Mr. Wilson did. And he re-Mirandized him and had him follow along. He said, he made clear you don't have to answer my questions. He talked for Officer Uberoff for exactly 44 minutes. Then Officer Uberoff kind of mutes his body camera, speaks to other officers. 16 minutes later, Detective Salmon comes. Detective Salmon lets him out the car. He tells him, you're not under arrest. You're out of the car. You're out of cuffs. You still don't have to speak with me. But do you mind speaking to me? He then speaks to him and reenacts. So all of this happens over the course of about an hour and 6 minutes. It's at an hour and 18 minutes into this body camera that Mr. White is called. So when one family member approaches the car and says, you shouldn't be talking, you don't have to talk. Mr. White was not called for approximately another 45 minutes later. No. And Mr. Wilson does not know who he was speaking to. He may now, Mr. Markarian has informed him, we didn't know who he was. He didn't know who we were. Even at the end of this body camera, this interview, Detective Salmon asked him, who's your lawyer? He can't answer it. Family members are all looking around. One young lady does answer, who I do recognize. I don't think is a part of this case, but we represented her boyfriend back in September. So I'm thinking they're trying to contact a lawyer and she had some information.
Okay. How did you even come to determine that there was a connection on this?
Your Honor, it's in the police report. it specifically states in the police report, and to clear up the timeline a little bit, I think we're having some,
Well, we'll first give you it's in the police report, it says that, Mr. Wilson contacts.
The Detective
Toby
Salmon
White,
does say
yes.
that. He said Mr. Wilson wanted to contact his attorney, Toby White. But you can see Detective Salmon out there asking, who's the lawyer that was on the phone? And some family members are scrambling, asking around, and some young lady off to the side says, that was Toby White. And Detective Salmon says, that didn't sound like Toby White. You sure that was Toby White? And it just kind of go, so I
So
think
this is before he talks to Detective Salmon then.
this was after. This was at the very end.
So why would Detective Salmon say that he wanted to talk to his attorney?
No, Detective Salmon asked them who was his attorney that was on the phone.
I mean, in the report, does the report say that Mr. Wilson wanted to talk to his attorney?
He said, I was interviewing Mr. Wilson, and at one point he got on the phone with his attorney, Toby White. That's, and it's just an isolated single sentence, and that's it in the
Okay,
entirety.
so because he,
Got that
Mr.
information.
Wilson referred to Toby White as his attorney, that's how it ended up in his.
Report. I think the family members, he didn't even know. He didn't
know who
answer.
called.
Yeah, he didn't
just
know.
took
He
the
couldn't
phone
even
and
answer who
was
was on
talking
the
to an
phone.
attorney, and it was told that it was Toby White.
And yes.
Okay, got it.
and to be clear on the reenactment portion, Your Honor, the actual, and maybe we're just playing semantics here on what we mean by reenactment. What happens is Officer or Detective Salmon approaches at the car, pulls him out. She's factually correct about that. She talks with, or he talks with Mr. Wilson. They start having some communication. He does start to walk him up to the house and kind of point out, hey, which door did he start at? Which door did he enter through? But the conversation with Toby White happens before Mr. Wilson is actually inside of the
No.
kitchen, reenacting the actual sequence of events. Detective Salmon looks right at him after the conversation that they, I think, have factually summarized accurately in their motion and says, are you good with that? Jacob Wilson then says, yes. And he continues to give his statement. So frankly, Your Honor, whether or not this is a conflict, whether or not legal advice is given, again, it's a ruling that Your Honor should be making on this case at this point, just because
totally
there
agree
is
with
an ethical issue with someone speaking to police after consulting with a lawyer, the lawyer telling them that they didn't need an attorney, that which would still potentially be legal advice, and then him continuing to give a statement to the police that Toby White Law Firm now wants to use to cross-examine that same person and also charge that same person with, based on Mr. White's emails to us.
And Your Honor, just so the record is clear, no facts of this case were discussed. No facts, no charges. I have the entire excerpt in the motion. Literally, it was, you don't need a lawyer.
I recognize that, no, I'm very clear, based on what you both said, that facts were not discussed during the call. Facts could have been discussed though, because from my understanding is he was called because he didn't, Mr. Wright was called because they didn't want him speaking. Mr. White could have potentially said, what's going on? Versus what's the state here is, if you are a suspect of a crime at this point, and time will say, well, that you will speak to me. Another attorney, it could have been him or another attorney who may have asked more questions before they decided to tell you, hey, don't speak to the attorney or don't speak to the officer. You may be a suspect. And so I understand his concern, because for there to have been a conversation where I see limited information about the actual facts were given, and then Mr. White is telling this individual that it's okay to speak to the officers, then later on, Mr. White is now saying this person should be charged based on information that is possibly given after he was told by Mr. White it's okay to speak. Well, I would think there was some red flags there too. I would too. Because if someone called an attorney's office for some counsel as to whether or not I should be speaking to an officer, that's for legal counsel. Not to say that you all are giving an engagement. It's more or less just like you would do a preliminary consultation. Do I need an attorney? Let me speak with an attorney and see if I need to get representation. And so there wasn't a lot of information that was exchanged. And Mr. White went based off of just the language that apparently Mr. Wilson used, which was that I'm not a suspect, I'm a victim. Oh, okay, well then you don't need to. So now I understand why they don't believe that there is a conflict. I see how this got messy, but I am my understanding is, I think both people acted reasonably under the circumstances. I don't think that his belief is unreasonable based off what I'm hearing. I also understand why the state bar would say to you that based on the information you provided, there wasn't real representation there. It was really like a very limited preliminary consultation. Do I need an attorney? If you're a suspect, you shouldn't talk. You can tell someone on the side of the street that. You don't have to know anything about those individuals. The person says, I'm not a suspect, I'm the victim. Oh, well, then you should talk to the police. That's real basic, bland information. And because of that, I don't believe that there is a conflict. The other thing that I don't believe makes it much of a conflict is he'd already talked to Officer Uberoff extensively. If it's a 44-minute conversation before you go now and ask if you should talk to Detective Salmon, and maybe he had already given some information to Detective Salmon. But he waived his rights. He understood that he was giving statements to an officer and that those statements could be used against him. And so now that the statements are possibly going to be used against him, he can't now assert that he was wrong. He waived that right. I don't believe that Mr. Wright got enough information to make this an attorney-client relationship. I don't believe that happened in this particular case. I think it could have if he had asked for information. Well, what happened? Let me see if you really are a suspect. He didn't even bother to do that. So that I think is where it keeps him from having a conflict. So for that reason, I'm going to deny the issue of a conflict here. And
if I may, Your Honor.
yes,
My other concern is, I think you aptly pointed out, is the potential for Mr. White being a witness on this case. And I understand that we're going off of what's in the motion. I'm not saying anything in the motion was untrue.
a witness as it relates to what?
Because as Your Honor aptly pointed out, more information could have been given on these phone calls with the family. What happens on the phone calls with the family all happens off of body worn camera. I have no clue what information was or was not provided to Mr. White prior to this conversation with Mr. Wilson. It could have been bland, it could have been benign, it could have been more.
But Mr. White was not on the call when the alleged incident occurred. Was he?
He was.
No,
The incident
Or
occurred?
excuse me, when the act, you were
when the
referring,
incident.
you're talking about this incident that we're here for, the actual home invasion.
Well, the crime. Was he
No.
on the phone when the
He was on the
alleged crime
phone
occurred?
until, he wasn't on the phone until after Detective Salmon got there, as far as I can tell. But what I can tell is that a member of the family comes in with the phone. And as we see in the motion here, it sounds like they did have a conversation with members of the family prior to that phone being handed over, which Toby White is then on the call. I can't hear that point when Detective Salmon is there. I have no idea what happened on that call prior to that person coming in and handing the phone to Mr. Wilson. That is my other concern, Your Honor. And that's the other reason why I felt to bring this up to Your Honor. And frankly, because I'm switching courtrooms too, and I didn't want to leave this much of a headache for me.
I understand. I don't know what happened on the phone call prior to the person, Mr. Wilson, getting on the phone with Mr. White either, but I don't see how that makes Mr. White a potential witness.
I understand, Your Honor. This was just, I consulted with many
the crime.
people at our office,
It's not a witness to the crime.
including our appellate unit and all that, and that they just wanted me to raise all of these concerns. That's frankly, honestly, why all of this happened is because I've been advised by just the state bar, the superiors at my office, and even had them proofread these emails before I sent them,
Understandable.
that this is what.
No, I don't believe that you acted improperly in doing your due diligence. Sometimes the role of a prosecutor and the role of a defense attorney could get messy in this regard. I don't believe that we should automatically assume that we're attacking each other,
I agree.
but that we are both zealously advocating that to make sure everyone's rights are upheld. And sometimes it could be a lot of camaraderie, sometimes it's not. And you're learning early on that sometimes it's not. I hope that Mr. White and Ms. James don't hold this against you. I don't think that he was acting viciously or in bad conscience. I think he was, if I had heard that information too from the victim, I probably would have had to flush it out myself. And then whoever he spoke to, which was, I don't believe, Ms. Chandler,
No, I didn't
gave
speak to
him information different from what obviously you were provided. I know Ms. Chandler, I'm not sure who you spoke with. And so if they being officers of the court as well, having never presented themselves in the court to give me cause to misbelieve what they're saying, say that they made these calls to the state bar. And then, again, this is information they gave very early on that they were going to flush this out. I don't see why they would tell the court this and then not go and do it. And then now understanding some more dynamics of the time frames in which certain things happen, I don't believe that there is a conflict that exists. I think there was a fine line that could have been crossed had Mr. White asked additional questions prior to telling him, yeah, well, you're fine to talk. If he had to determine whether or not he was a suspect or not, that's different. He didn't sound like he did that. It sounds like he relied on whatever the guy told him. I'm not the suspect, I'm a victim. Okay, well then you shouldn't need it. You shouldn't need an attorney. That's very bland information there. So we're,
If I may, Your Honor.
you
just
may.
For clarity of the record on a couple of points, when I spoke to Mr. Wilson about this first call, that I didn't provide the information about who Toby White was, that he had spoken to Toby White. I advised him who the defense attorney was, and he started to immediately scream and yell over the phone about how upset he was, asking if he could sue Mr. White, asking what his rights were. I told him I don't give legal advice, and that's not my job. After that, one other thing I'd like to clarify for the record based on the motion is there seems to be some assertion of a conspiracy between myself and the victims on this case. I have not talked to either of them since that call in November. So this idea that they were served with a subpoena on September 17th, they then called me and I wrote this email on December 18th is absurd. And I do it.
I don't know if it's absurd.
It's
It's just it's just how it just the same way you got information that caused you to formulate a belief about the timeline and how things could happen. They have a similar set of circumstances here. It was just a perfect storm. They're having some difficulties getting information from your potential witnesses. And then right after that, there's this motion. So it's just a perfect storm of events.
And I understand, but to put those assertions in a motion filed with the court, that's what I say.
I get it. I mean, you didn't actually put yours in a motion, but you put some pretty heavy assertions here in this email. I remember reading it and, you were concerned and you weren't mincing words. And so, but you're doing your job and they were doing their job. And sometimes, again, it could cause there to be some back and forth. And I see how this could get messy. This was a situation that could get messy. Not something I think can happen often, but in this particular circumstances, it got messy. And so the court is the appropriate person to flush it out then. And you just did. And so the motion for a to show cause is denied, as I don't believe that there was or is a conflict that exists at this time. And I completely believe that Mr. Wilson is probably upset and he does believe he can sue. But we have that all the time, don't we? All the time. People always misunderstand how things work and believe that they have now the right to sue over things they don't have the right to sue for.
Difficulty of obtaining information.
Right, but if he believes he can sue civilly, good luck to him in that. Hopefully I don't get the case. And then maybe there's a conflict there. And then we can move on with the criminal matter as it relates to this, because this still needs to have a date for an exam. Is that correct?
Yes, sir.
I believe we're.
Oh, the
set for
17th.
17th.
Okay, so we're proceeding on the 17th on the exam. And Mr. Nagel will be handling this, or?
Yes, Your Honor.
Okay. And continue to do what you're doing to clear up these types of issues. I'm actually far more concerned about you following a show cause on that one.
The one from this morning, Your Honor?
That I'm concerned.
I figured I already have one of those today.
Thank
I didn't need another.
I was sitting there thinking, like, wow, what's going on? Okay. And so we flushed that one out. That one will continue to examine any additional matters for today's record.
Nothing from the people. Thank you.
Nothing from defense.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Happy, healthy new year to you and your
Same
staff.
to you.
Thank you.
Respect that.
All right. Now we're gonna-
And that'll take care of that.
PE, so just throw them back there.
If, unless they're in jail.
All jail files, just throw them in the hot box.
Yeah.
And then this guy was the bench warrant.
Did
that
you
right
do the bench
guy?
warrant? I can do the bench warrant. Oh, okay. And then this one needs to go in the hot box. So this one can go out
This-
with that.
This is next
action.
action.
Yeah.
Okay. And then this is.
So that's next.
Next action, I think.
Yeah.
Oh, talking.
You can see Miss Donnelly walking down the hall.
If she's ready, I'm gonna have her have him bring up green.
Okay. Green, you said first?
Yes. I assume that's the one you all are addressing. Green is the one that we gotta address the witnesses.
It's an adjournment request. yes.
Yeah, so I'll have him brought up first. Okay.
Oh, you're here for green?
There's something else. but Green's- He's here.
Where are all these
That's all right.
came from?
It's just a punt. Punt this down the road for 6 minutes to see if it shows up.
I'm gonna have to like. Can we bring up or have Green be brought up, please?
Green, I'm reading.
I gave up. Like about 2 years in United
Oh.
States, I gave up. I was like, you know
Never
what?
give up. Right.
Yes, you did.
Your name's This is Mr. Green.
Yes, Your Honor.
Okay, on the record in the matter of the people of the state of Michigan versus Trayvon Deshaun Green, 24-02349, appearance, please.
Good morning, Your Honor. Case Mark Herring appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Trayvon Green, who's to my right.
Okay, Mr. Green has an exam today for unlawful use in a misdemeanor domestic violence. How are we proceeding?
Your Honor, at this time, the people would be requesting an adjournment of the preliminary exam due to Officer Kiefer Davis's unavailability today. Officer Davis did reach out to me on this matter and advised that he had surgery scheduled for this morning, so he was going to be unable to attend. It sounded, I didn't get too much into his medical information, but it sounded like it was relatively minor surgery. So if we adjourn this out maybe a month, that might be enough time.
Officer, is one officer?
Officer Kiefer Davis, yes, Your Honor, that would be the witness that I would need to call.
And was there a lay witness that was supposed to be here?
There was Anna Brito. I have attempted to contact her a few times. We've never gotten in touch, but this is one that I'm intending to run victimless with Officer Davis, even if we don't make contact with Ms. Brito.
And this Officer Davis did not appear on November 1st.
Correct, Your Honor. I know that this was already adjourned once due to his unavailability. And I advised him of that. I advised him I would attempt to make the request and we would see what Your Honor decided.
Thank you, Your Honor. I just wanted to say that everything is so far stated on the record is correct. It's my understanding that the officer wasn't available. I don't recall what the reason why he wasn't available last time, but he wasn't here. And they did intend to run this victimless. We would just obviously still continue to object to any adjournment, Your Honor, and request a dismissal without prejudice.
Motion to dismiss is granted because this is the second time the officer has failed to appear on this matter. And he's being held on a 15,000 10% bond for a high court misdemeanor. They do have the right to reissue this charge against you. Do you understand that? Get your copy of dismissal in just a moment. Do you have any questions for the court? Additional matters for the record.
Nothing from the people.
Not from defense.
And then we have
Bush and Wilson. Should be the wrong one.
okay, what are we doing with Wilson?
It should be a waiver on Wilson, I think.
Yes, it should be a waiver.
We'll have Wilson brought up. Mr. Fife is running another exam.
Thank you. Real quick though.
Yeah, I'm sorry.
I'm gonna go check on Mr. Pfeiffer real quick while he's brought up.
Yeah, this is copy. Yeah. Okay, on the record, in the matter of the people of the state of Michigan versus Lantrell Wilson, 24-02769. Yes, please.
Good morning, Your Honor. Case Mark Theron, appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of Defendant Lantrell Wilson, who is to my right.
Mr. Wilson has a receiving and concealing firearms, weapons carrying concealed, possession of meth, and possession by prohibited person, habitual offender, third offense notice. There was a exam scheduled for today. How are we proceeding on this?
I believe there's going to be an unconditional waiver by both parties here today, Your Honor. For the record, the offer on this case was to plead to count 2 of carrying a concealed weapon. In exchange, we would dismiss the other 3 counts and the habitual third offender. That offer will continue to circuit court.
That is our understanding of the offer and what right at this moment we intend to take in circuit court.
Just set this for. Oh.
Yeah,
They actually need resolutions.
yeah. That's what they said.
A misdemeanor resolution?
Yeah.
Lord. You wanna get me the 2022 case in 2025?
Your Honor, may I approach?
Yes. Okay, so Mr. Wilson, do you understand that you have the right in this matter to have a preliminary examination in the district court because you are being charged with felonies? Do you understand the purpose of the exam?
Yes.
So you have the right to require the prosecution put forth evidence here at the district court level that would establish whether or not they have sufficient probable cause that felonies were committed and probable cause sufficient to charge you with those felonies. You understand that?
Yeah.
And you wish to unconditionally waive your exam?
Yes.
Anyone threatening you to do that?
Nope.
Has there been any promises made in exchange for you giving up your exam?
No. Other than.
The plea offer?
Yeah.
Other than that, correct?
No.
The grind over date is January 15th. That's the date the circuit court's gonna get the file from the district court. You do not have to appear in circuit court on that date unless for some reason Ms. Donnelly's making a motion to have you rearranged, okay?
And Your Honor, can you tell me the date one more time?
The 15th. If she makes that motion, then you will have to appear on that date. Otherwise, your next court date will be a pre-trial. You understand that?
Yeah.
What's my name? You have any questions at this time?
Oh,
So you say you are gonna make that motion?
I'm going to email the court today to see if I can get, is it possible? Obviously, Mr. Wilson's in Nuevo, so we need to make sure we can get him there.
looks like his bond was set at 10,000 personal recognizance. That will continue. Any additional matters for the record?
Nothing from the people.
Nothing for defense.
Thank you. You're all set. And then we were just waiting for
Bush.
Bush, but,
When I checked, it sounded like Flores was making his bind over decision in there. So
oh, okay.
we'll see if that's left. So.
There was no